Okay, good afternoon, everybody. So let's see, let me check and see if we've got everybody. It looks like people are in. And let's see, based on the numbers, I think that would would be quorum. And let's see, I see Mr. Lightcap is with us. And let's see, it's Judge Woodard. Judge Woodard, are you on? He might be running a little bit behind. Oh, there he is. Gotcha. Okay. So thanks for joining us, everybody. I think we've got a great presentation lined up for you today. Just a little bit of section business. It's been a while, so we're going to go ahead and hold elections. And today we have just all officers are up on the ballot. That's going to be myself for chair. That's going to be Judge Woodard for vice chair and Alan Lightcap for secretary. I did not receive any nominees. If that's not accurate, please feel free to message me if you had a nomination in mind. I'm going to hold maybe about 30 seconds, and then we'll go ahead and put the poll up. And we're going to conduct it by Zoom poll. That seems easier than just counting or doing viva voce. It's hard to do over Zoom. So we'll just do poll results. And again, give about maybe 30 seconds and then we'll put it up. And Lane, I'll let you know when to go.
Okay, great.
And Dom, can I just make a quick addition to that?
Sure.
Okay, so hey everybody, Alan Lightcap here. Just wanted to say that you don't have to necessarily be a member of the, committee that runs the section in order to be involved. We would love to get any suggestions or help or any help that you might have in CLE ideas or social events or ways that the admin law section practitioners can help each other. We would love those ideas, and we're all available by email. We'll take you to lunch, and we'd love to have just more of a vibrant section, especially coming out of COVID. Hopefully next year we'll have a number of really great events. So thanks, Tom.
Yeah, absolutely. I wholeheartedly agree. Anytime anyone has an idea for some kind of section hosted presentation or CLE or just an event, because we've had events before. We've had the viewing of the Euros. It doesn't necessarily have to be academic or a presentation. It can be just a meet and greet type thing. We're always open to ideas. You're welcome to send it directly to me or to Alan or Judge Woodard. And we'd love to hear from you. Okay, so I think we're ready to go. So Lane, whenever you're ready, we can go ahead and put that poll up.
Okay, the poll has been launched.
Thank you. We'll just give it a couple of minutes. I do apologize. I tend to, when I was doing the schedule, I tend to allow 15 minutes for voting. In my experience, it usually does not take that long. And yet, but so it's kind of overkill as far as the amount of time I allowed. I do have Professor Volokh is scheduled to start speaking at 2. So we'll just allow a few minutes. Maybe people are still arriving. And then once the results are in, we can go ahead and announce, and then it'll be a couple minutes and then we'll move forward. And Lane, did you see Jennifer's comment in the chat? It looks like she's having trouble seeing the poll.
Yes, she will just need to click on the more button at the bottom of the screen, and it should give her an option for the poll, or there should be a polling button at the bottom of her screen that she can click on.
Okay, great. Thank you.
Okay, and we have 24 out of our 31 participants that have voted, and we have unanimous yeses on all three.
Okay, excellent. So I guess then we'll call that closed. Okay, well, I don't really have any further announcements, so I think what I'm going to do, I'm looking at the agenda now. It looks like I did. I basically allowed 10 minutes for the election, so I did. I guess I less time than I thought. So I will go ahead and introduce our speaker. It's our great pleasure to have Professor Volokh back with us. For those of you who were unable to join us last year, he gave an excellent presentation on the non-delegation doctrine. I thoroughly enjoyed it. This year, we're very lucky to have him join us once again. Professor Volokh, he's an assistant professor at Emory University School of Law, where he teaches administrative law, constitutional law, and law and economics of antitrust. He earned his Bachelor's of Science degree from UCLA and his JD and PhD from Harvard University. He's clerked for Judge Alex Kaczynski of the Ninth Circuit Court of Appeals, as well as United States Supreme Court Justices Sandra Day O'Connor and Samuel Alito. He's an expert on admin law, and he's the author of many legal articles, and he's a regular contributor to news media. Today, he's going to be presenting on the major questions doctrine. And thank you so much, Professor Volokh, for joining us. And whenever you're ready to go, you can get started.
All right, excellent. I realize since this is the admin section, many of you are experts in admin and maybe you even know more than I do. And in any event, some of what I'm saying may be old hat to you. So I'm going to try and, leave as much time for Q&A because that's probably going to be more useful. At the same time, one reason why I became a professor, like many of my colleagues, is, we like to hear ourselves talk, and also just to explain the thing takes a while. So I'm going to see if I can balance those two goals. Here I'm going to share my screen, and we can look at some PowerPoints. So we're going to be talking about the major questions doctrine. And like Dominic said earlier, I had talked to this group about the non-delegation doctrine, and it turns out that the two doctrines are kind of related to each other in an indirect way. So the major questions doctrine, the huge case on that just in the last days of the Supreme Court term that just finished was West Virginia v. EPA. What I'd like to do is start up with the relevant prehistory and build our way up to where we are today. So we're going to start with the prehistory is we have the Article 1 non-delegation doctrine. I like to call it not just the non-delegation doctrine, I like to call it the Article 1 non-delegation doctrine because there's a number of distinct non-delegation doctrines, but this is the one that most people talk about. And it's the one that's based on the vesting clause of Article 1. It says that all legislative powers herein granted shall be vested in a Congress. And that's always been taken, I don't know if it's right, but it's always been interpreted to mean that Congress can't divest itself of its legislative powers. It can't delegate its legislative powers. Now, of course, Congress delegates power all the time. There's no problem with delegating power. It just can't delegate legislative power. So if it passes a statute, then there's it can delegate the power of enforcement to the executive branch or, and so on. But it can't delegate the power to legislate. And how do we tell the difference between those two powers? is not just a formalistic power of the power to cast a vote in Congress. It's more of a functional analysis. And so the black letter doctrine says that if Congress delegates its power, but delegates some power, but provides an intelligible principle that the delegate is supposed to use, then that's not a delegation of legislative power. Rather, it's a delegation of something else. It might be a delegation of executive power or something like that. So in other words, you might say that implicitly this is defining legislative power as the power to make rules, quote, I'm going to say arbitrarily, but not in a bad sense, just in a way that's not controlled by any pre-existing principle. Congress can do that, but let's say the executive branch can't do that. Now, that's only been used twice to invalidate delegations. Both times it was delegations to the president, and both times were in the year 1935. And those were the cases Schechter Poultry and Panama Refining. It was part of both times. It was part of the same statute, FDR's Big New Deal statute. Both times it allowed the president to do something. In Schechter Poultry, it was approve an industry proposed regulatory code for the industry. In Panama Refining, it was whether to flip an on-off switch about whether shipments of oil, contrary to state law, would be also contrary to federal law. But in both cases, it allowed the president to do something and gave him no guidance as to how to do it. So the Supreme Court said, okay, there's no intelligible principle there. That's a violation of the non-delegation doctrine. But that said, since 1935, the Supreme Court has been really notoriously lax about enforcing this doctrine. So it has always upheld delegations, mostly to the executive branch, and it has upheld them by finding that there was an intelligible principle. But if you look at those cases and you look at what the intelligible principle is, it's kind of laughable. There were cases that said that an agency has to disapprove corporate organizations that are unduly or unnecessarily complicated, or allocations of corporate voting power that are unfair or inequitable, or has to set prices at a level which is, generally fair and equitable, or grant radio and TV licenses in the public interest. And so if public interest is an intelligible principle, then it looks like anything can be an intelligible principle. So, it looks like this is not really a very heavily policed doctrine. Okay. Now that might change in the next couple of years, and I'll get to that. But right now, that's where we're at. So that's our prehistory. Now, since 1935, like I said, the Supreme Court has always upheld delegations against direct challenge, but it's possible that it has been using non-delegation ideas as in the background as a kind of avoidance canon. That is, for example, interpreting statutes narrowly in such a way as to avoid non-delegation concerns. So one classic example is the benzene case. The benzene case is the nickname that we all give to it. It's like Industrial Department, AFL-CIO, the American Petroleum Institute, or something like that. But it was a case involving OSHA workplace regulation. It came up in 1980. The OSHA Act, there's the organic statute of OSHA, said that OSHA had to set up occupational health and safety standards. And what that meant was, and I give the text there, a standard that requires practices reasonably necessary or appropriate to provide safe or healthful employment and places of employment. And then there was also another requirement for if the agency wanted to adopt toxic standards, and that was a more stringent definition. And there was no majority opinion there, but the plurality said that when it says reasonably necessary or appropriate to provide safe or healthful employment, that's not just boilerplate language. It doesn't just require a kind of rational basis. It actually requires a threshold finding that under the status quo, the chemical conditions at the workplace, it's more likely than not to present a significant risk of material health impairment. So they actually interpreted it to require very specific findings, threshold findings by the agency. And the dissent said, no, that's not plausible at all. Like maybe that's good policy in your view, but that's not what the statutory language means. But one of the reasons that the plurality gave is they said, if we interpreted it otherwise, then it would be a sweeping delegation of legislative power and it might be unconstitutional, and that we should construe the statute to avoid an open-ended grant like that. And so that was an early case, not necessarily the earliest case, but it was that's just a well-known case where non-delegation doctrine was not used as such, but the ghost of the non-delegation doctrine was used as a kind of avoidance canon to interpret a statute. And now you can really easily criticize what they did there, because the non-delegation doctrine is not about delegating lots of power over industry. Congress is allowed to delegate lots of power over industry, just as long as it does it in a bounded way with an intelligible principle. And was there an intelligible principle here? I mean, if you look at the statutory text up at the top of the slide, practices reasonably necessary or appropriate to provide safe or healthful employment and places of employment. Now, Rehnquist had a concurrence in the judgment where he says that's totally meaningless because all of those are just general terms and someone's got to put meaning into them. They don't have meaning in themselves. And so you could take that view, but the plurality didn't say that. And under the whole case law, those words are at least as specific as generally fair and equitable, or public interest, or other things that had routinely been upheld. So the idea that this would be such a broad power that it might violate the non-delegation doctrine, that's kind of a non sequitur, because the non-delegation doctrine is not against grants of a lot of power. The non-delegation doctrine is against grants of unbounded power, even if it's very narrow, but if it's unbounded, it's you have to give bounds. So there was a kind of a mismatch between this avoidance canon and the doctrine that it was supposedly trying to enforce. Anyway, I've raised that because that's going to become relevant later, but I should also say administrative law is full of those sorts of implicit non-delegation rules. The whole idea that under administrative law, we, courts do hard look review or try very hard to make sure that agencies stay within the bounds of their statute and so on, because otherwise agencies would have unbounded power, and that might be a violation of the non-delegation doctrine. So you could say that a lot of administrative law is driven by a kind of unease about broad delegations and a need to control delegations. I mean, I would say that's what administrative law is all about. Okay. Now, that was 1980. Since then, we've had the big elephant in the room in administrative law is Chevron. Chevron was decided in 1984, and that also is all about delegation. Chevron is about delegations of interpretive power. What if Congress passes a statute and it's got a vague term in it? Well, who is going to define that term? And so you could say, well, the agency can think what it wants, but courts get to interpret all the vague terms de novo. That would be giving interpretive power to courts, which is how we usually do things. But Chevron says that actually sometimes Congress might delegate interpretive power to the agency, and then the court just has to respect that. So what the court said in Chevron, sometimes Congress explicitly delegates interpretive power in a statute, but sometimes the delegation is implicit. And so whenever there's an ambiguity in an agency administered statute, we are going to interpret that as an implicit delegation of interpretive power, and then we uphold the interpretation if reasonable. That's our standard Chevron two-step. And if from the very start, it's been conceptualized as an implicit delegation of power, but not of substantive power, but of interpretive power. And how the court justified it with two factors, which is that as between agencies and courts, agencies have more expertise, because after all, the EPA knows more about environment than courts do. And also agencies have more accountability because Article 3 judges are appointed for life, and they're not democratically accountable. On the other hand, agencies work for the president, and the president is democratically accountable. So that was Chevron. And the many volumes have been written about Chevron, but what I want to focus on right now is that this is a substantial pro-delegation canon. It transfers a lot of power to the executive branch. And as we'll see in the West Virginia case, it means that as as administrations change from Republican to Democrat to Republican to Democrat, you can have wide swings in agency policy. And so what was done by Obama can be totally reversed by Trump. It can be totally reversed by Biden. And that can be true with greenhouse gas regulation. It can be true with immigration. It can be true with, what have you. And so whether you like Chevron or not, I just want to point out here that it's in substantial tension with non-delegation values. And so on the one hand, we have the non-delegation doctrine itself, and we have all these shadow doctrines like the avoidance canon and other doctrines of administrative law that are about limiting these delegations. But Chevron is the very substantial doctrine, and you could call it a canon, which goes the other direction and cuts in favor of pro-delegation. And it's no surprise that there are some people like Justice Thomas or Justice Gorsuch, and they are simultaneously skeptics about delegation and skeptics about Chevron. Because the two go hand in hand. And if you're going to want to rethink delegation, then you want to rethink Chevron. And if you're uncomfortable about Chevron, it might be because you're uncomfortable about delegation. Now, Chevron was in 1984, and that's almost 40 years ago now. So, we're getting old. Since then, and especially in the last 20 plus years, there's been a lot of movement where Chevron, the main news item is that in the last 21 years, there's been a retrenchment of Chevron, but at the same time, it has, again, just like the non-delegation ideas, Chevron has not gone in just one direction. There's been retrenchment, there's also been expansion. So the main retrenchment I want to point to is Mead, right? 2001, we had US v. Mead, and Mead said, look, not all agency interpretations deserve to get Chevron deference. And Mead was a kind of a multi-factor test, but basically it said that the strongest case for Chevron deference is where the interpretation has, number one, the force of law, and number two, relative formality. And because there, it makes more sense to think that Congress probably intended to delegate interpretive power. And so the classic examples of that would be notice and comment rulemaking or formal adjudication. And what's the weakest case for Chevron deference? Where do we think that the Congress did not want to delegate interpretive power? And that's where the agency interpretation lacks these. It doesn't have the force of law, and it doesn't have relative formality. And so the classic examples of that would be interpretive memos or guidances. So Mead basically says, yeah, Chevron now has a restricted domain. It's primarily for notice and comment rulemakings or formal adjudications. Not only Mead itself arose, Mead itself said that sometimes even informal adjudications could get Chevron, but the primary domain for Chevron after Mead is notice and comment rulemaking and formal adjudication. And then when you don't, outside of those areas, the primary method is going to be Skidmore deference. That is just kind of a mere courts will respect what the agency says, but they still come to their own conclusion if they're not persuaded. Mead was usually interpreted as restricting Chevron. Even the Mead court said that we're just describing what has been practiced all along, but it hadn't been really explicit all along. So I'm going to say Mead is a retrenchment of Chevron. That's the conventional wisdom. There's also another way that you can retrench Chevron is you can say, well, I think that there's not a lot of vagueness out there. There's not really a lot of ambiguity in the statutes. If there weren't any ambiguity, then Chevron wouldn't matter. We would decide everything at step one, and we would never have the opportunity to decide whether the agency's decision was reasonable under step two. And so you might think maybe if we used our whole interpretive toolkit, if we used all the tools of textualism, but not only textualism, if we also used legislative history, and we also used purposivism, and we used every canon available to us, ultimately we could find a meaning of the statute. And then we could always stop at step one. Now, you don't have to think that, but you could say, maybe there are some judges who don't use the whole toolkit wholeheartedly. Maybe they want to defer to the agencies. But if you didn't want to defer to the agencies, you could use the existing toolkit very aggressively, and then you could find a clear meaning at step one. So now there are some people who think textualists are especially likely to think that. Scalia, actually in the early years after Chevron, he had a very influential late 80s Duke Law Journal article, and he said, because I'm a textualist, I'm really likely to find that the meaning is clear. I think that's a little bit of an non sequitur, and I'm not really sure whether textualists are more likely to find a clear meaning. But what I will say is, in the last years, the court has been insisting on using all the interpretive toolkit to determine the meaning of a statute. And so in many cases, you stop at step one and you never get to step two. In fact, the Supreme Court has barely used Chevron in the last several years, has barely cited Chevron in the last several years, and often it has decided cases even without mentioning Chevron. So these are ways that over time, Chevron can have a limited domain, so that even though, yes, it is a transfer of power to the executive branch, that transfer of power can be broader or narrower. And so maybe this is narrower and more of the power is being used by federal judges. Now, on the other hand, there is this case, I'm going to call it a recent case, even though now it's been 9 years, City of Arlington v. FCC. And the main issue in the case was whether the FCC, the FCC had to interpret the statute just to interpret whether it had jurisdiction over that particular case. And the question is, does the agency get Chevron deference in interpreting its own jurisdiction? And the Supreme Court said, yes, it does. But one of the side things it said in getting there was you didn't have to show that there was a specific congressional intent to delegate interpretive power as to the jurisdictional question. All you needed was a congressional intent to delegate interpretive power overall as to the entire field of regulation. And so for the FCC, yes, clearly for the whole Communications Act, there was such a delegation. So City of Arlington stands also for this minor proposition. There's no need to search for specific delegation as to a particular question when Congress has given a general power to promulgate rules in a general field. So that's been a kind of, you might think of that as kind of an expansion of Chevron. So since 1984, we've, especially in the last 20 some years, we've had some retrenchment of Chevron, at the same time, some expansion of Chevron. Every time there's a retrenchment, it is a kind of anti-delegation move. And every time there's an expansion, it's a kind of pro-delegation move. So at step one, which interpretive rules do we use? And so, like I said, generally you use the entire interpretive toolkit. Chevron itself actually said that. The famous footnote 9 of Chevron said that you use your whole interpretive toolkit at step one. So like I said, many cases don't even cite Chevron because they just say, well, the meaning of the statute's clear, so it doesn't matter whether we had a deference regime or not. If the statute clearly denies power to the agency, then we're done. And so here's one factor that's been increasingly used. It's whether the question is major. And they didn't always use the phrase major question, but sometimes they just said, you know, this is a question of exceedingly great importance or something like that. And so just recently in West Virginia, the court was summarizing those cases and said that sometimes there are extraordinary cases, and where the history of regulation in a particular field or the breadth of the power that the agency was asserting or the significance of the decision, it should make us hesitate before concluding that the agency had the power. So for example, Brown and Williamson, whether the FDA can regulate tobacco and cigarettes. Gonzalez v. Oregon, the AG could always pull someone's medical license for being contrary to the public interest, but did that give the AG the power to say that it was contrary to the public interest for a doctor to be prescribing assisted suicide medicines in a state where that was legal? The Utility Air Regulatory Group, that involved an interpretation of the Clean Air Act, which would have extended EPA regulatory power into every tiny business and household, because, you know, once you have greenhouse gases in the mix, then the particular thresholds were so low that they would reach into every corner of life. Alabama Association of Realtors last year, whether the CDC could adopt an eviction moratorium as part of its power to control the spread of disease. And just this year, NFIB v. OSHA on whether OSHA can adopt a vaccine mandate on employers. as part of maintaining safe workplaces. So the court has said that some of these are cases where it really they're extraordinary because the questions are very big and very significant. The agency is asserting a very broad power, which is kind of out of whack to how it has asserted its power in the past or to the context where that old statute was adopted. So this major question, that's one factor that the courts use, and it's in determining the meaning of the statute at step one. And so if you determine that the agency lacks the power, you're done, and you don't even get to the point of whether you defer to the agency under Chevron step 2. All righty. So now, having wound this all up, let's get to this case just from late June, West Virginia v. EPA. Okay, so West Virginia v. EPA is a very big and complicated case. And as you know, you guys who do admin cases arise in all these very different fields. And you have to understand a case, you have to become an instant expert in communications or enviro or food and drug or labor management or immigration or wherever this arises. So I can hardly do this justice in this short talk because the Clean Air Act is complex. So I encourage you to read the case, but I'll try and tell you the minimum that's necessary to figure out what's happening. Here we have, it's a Clean Air Act case, and it involves Section 111 of the Clean Air Act, the new source performance standards. So the EPA needs to set standards of performance for new sources of air pollution. And for new sources, it has to set the standards based on a technological criterion. It has to identify what is the best system of emission reduction for these new sources. And historically, that's been something technological, like install scrubbers or something like that. Anyway, so best system of emission reduction, that ends up being important. Now, 111 is mostly about new sources, but 111D also provides for the regulation of existing sources. And so if there's like new power plants, then what about the existing ones that are just like those new ones? So if they would be regulated in a particular way, if they were new, then 111D says, yeah, we have to come up with regulations for these existing ones too. Now here, the states have the primary role, which is the states have to submit to the EPA their own plans to regulate existing sources. EPA is allowed to step in, but only if the state has failed in that job. So now here's the issue. You have all of these existing coal-fired power plants, many coal-fired power plants, which are dirty. And you could do just technological-based fixes on the order of scrubbers and so on. But the fact is that that only leads to very small reductions in pollution. So in the Obama period, the EPA was thinking, well, how can we get these existing sources to reduce pollution more? Okay, and so during Obama times, the EPA introduced this regulation called the Clean Power Plan. And there, the EPA did something new. That is, instead of just having a technological fix that could be implemented at the very plant, it relied a lot on so-called generation shifting, that meaning shifting to production at other cleaner plants. So if you were an existing coal-fired power plant, you could do things like install scrubbers, but that would only get you a very small portion of the way. How would you get the rest of the way toward the requirement? One way is you could just shut down part of the time and produce less. Another way is you could build a different power plant that is not, runs on natural gas or renewables or whatever, or you could invest in such a plant. And another way is you could do a cap and trade system where you could essentially buy credits from cleaner plants. So that was a very new approach, because the EPA now, for the first time under 111D, looked into methods of reducing pollution which were not technological things that could be done on site. And just look up at the top of the slide. it has to be based on the best system of emission reduction. And so the best system of emission reduction historically meant technological fixes on site. Whereas here, the EPA took the position that the best system of emission reduction might be shut down, or it might be build a different power plant, or it might be buy credits from other power plants. In addition, I'd have to say the EPA's basis for the whole plan is kind of questionable, because at least the way I read 111D, it looks like the EPA is not even allowed to set these requirements. It's the states that have to set the requirements. The EPA's power is only limited to approving or disapproving state plans. But that's another issue. In any event, because of these legal problems, the plan was immediately challenged, and in fact, it never went into effect. Now, that was proposed very shortly before the end of the Obama administration. So when Trump became president, under the Trump administration, they said, okay, let's put this plan on hold anyway, because we're going to withdraw it and have something new. And so the litigation was put on hold, eventually dismissed as moot. And under Trump, the EPA replaced it with this affordable clean energy plan. And the EPA explained the reason we're doing this is we think the Obama era clean power plan was actually illegal because generation shifting is not a thing you can do under 111D. And so it was a much less regulatory plan. It had much less in the way of pollution reduction, and it didn't have any generation shifting. Anyway, then Biden became president, and the Affordable Clean Energy Plan is off the table anyway. This is exactly what we were saying before of you can have wide shifts in policy between Democrats and Republicans as you have changes in administration. Okay, so the question is generation shifting a thing that you can do as a best system of emission reduction under 111D? And here is a lengthy quote, but I just wanted to give this to you just to see what the court said. And so the court's majority opinion said, and I'm just going to read it here. EPA claimed to discover in a long extant statute an unheralded power representing a transformative expansion in its regulatory authority. It located that newfound power in the vague language of an ancillary provision of the act, one that was designed to function as a gap filler and had rarely been used in the preceding decades. And the agency's discovery allowed it to adopt a regulatory program that Congress had conspicuously and repeatedly declined to enact itself. Given these circumstances, there is every reason to hesitate before concluding that Congress meant to confer on EPA the authority it claims under Section 111D. And so the court goes on to say that in those sorts of circumstances, we're not just going to assume that Congress delegated that sort of power. We need a clear statement. And that is a reversal of the presumption of Chevron, because under Chevron, when there's a vagueness in the statute or an ambiguity in the statute, we don't require a clear statement. We actually just casually assume that that is a delegation of interpretive power to the agency. And then we look to the agency's interpretation, see if it would have been reasonable. Now, after Meade, that has a smaller domain, but this was a notice and comment rulemaking. So this is clearly still in Chevron's domain. And so normally we don't look for a clear statement. But so under the West Virginia approach, now when it's a major question, then we actually do need a clear statement on this specific 111D question. And that is a total reversal of the Chevron presumption in light of what we saw in City of Arlington, where you do not look to congressional intent on specific questions, as long as there's an intent to delegate regulation of an entire field, which is clearly the case here. So this is basically the major questions doctrine. Now, Gorsuch signs on to the majority, but he also writes a concurrence where he gives more theory on the doctrine. And here's what he says. He says this is part of a long line of clear statement rules that indirectly enforce constitutional guarantees. For example, the ex post facto clause says you can't do retroactive lawmaking, but even in non-constitutional cases, when we're just interpreting a statute, we try and interpret statutes in order to avoid retroactive effect, and we require a clear statement for that. Same for abrogation of sovereign immunity. Generally speaking, Congress can't abrogate state sovereign immunity, though it could if it's operating under Section 5 of the 14th Amendment. But even where Congress arguably could abrogate state sovereign immunity, as a matter of statutory interpretation, we look for a clear statement that they've done so, and we won't casually assume that they've done so. So you have these clear statement statutory interpretive rules, clear statement canons, and they indirectly enforce some kind of constitutional guarantee. And so this major questions doctrine enforces the non-delegation doctrine. It's just like the benzene case, though actually Gorsuch pulls out a case even from 1897, where the Supreme Court seems to have applied something like that. So how do we know whether something is a major question? And he goes into greater detail than the majority opinion did. He says, it's an issue of great political significance, like physician-assisted suicide, or COVID, like vaccine mandates, or that sort of thing. And he says it's very telling if, as a matter of history, if there have been bills seeking to grant that kind of power, and Congress has considered those bills and rejected them. So another aspect is, if it's another thing that makes it major, is if it regulates a significant portion of the American economy, or if it requires billions of dollars in spending by private persons. So for example, greenhouse gas regulation, or can FDA regulate the whole tobacco industry? So that also makes something a major question. Then there's another factor. Does it intrude into an area that is the particular domain of state law? And in that sense, there is also a federalism canon. And so he says the major questions canon will overlap somewhat with the federalism canon also. So you might say, eviction moratorium, maybe that intrudes into landlord-tenant law. And so that's not an area that CDC usually gets into. So those are various things that make a question major. And what sorts of things do you look to? You look to the statutory context, you look to the age and focus of the statute. For example, if it's a really old statute that was enacted for a different reason, you're more skeptical. The agency's past interpretation of the statute. So just like the court had said in the majority, if the agency has never asserted a type of power, and then 40 years after the statute's passed, for the first time it comes out with an all new and very broad interpretation, then that makes you suspicious, or a mismatch with the agency's expertise, and so on. So basically, Gorsuch agrees with the majority, but he gives more theoretical reasons and more flesh on how you would say whether a question is major. All right, now I'm going to conclude here by saying, does this make sense? And I got to say, I am actually a fan of the non-delegation doctrine. I think we ought to enforce non-delegation norms more strongly than we do. So I see where they're coming from, and I am broadly sympathetic with the general agenda. But I am not a fan of the particular way that they're doing this, which is the major questions doctrine. So I don't think the major questions doctrine makes a lot of sense. So in the first place, Chevron has a very broad background rule of implicit delegation. Now, I am a Chevron skeptic. I think that it would be a good idea if Chevron were overruled. I know Gorsuch does too, because he said that, and this is one of the big questions that we have in our betting pools as admin people, is will Chevron get overruled? They recently had the opportunity to overrule our deference, decided not to, but they took pains to say this has nothing to do with Chevron because they all knew this is coming down the pike. Anyway, so I'm not wild about this whole very broad rule of background rule of implicit delegation that Chevron gives us. And so I would cut back on that. But what this doctrine says is we still have a very broad background rule, but now we have an opposite rule for major questions. Okay. Now, also, what makes something a major question? That's somewhat subjective, because you have to look at the social and political significance. And you have to look at whether it's a big part of the American economy. Now, it's hard to say whether something is a big part of the American economy. Like, on the one hand, you might say electric generation is a major part, but what if you have a minor regulation on a major part? What if you have a major regulation on a minor part? So, this is all very subjective, and what it means is there's the danger that judges will use this in an opportunistic way to strike down things they don't like. Of course, that's a big hazard in admin already, and we all know that there's a lot of politically based decision making or ideological decision making. But every time you introduce a new doctrine like that, you increase the possibilities. You increase the ways that they can do that. Now, what about focusing on the social significance? One of the things that they say in the case is you might have to look at the salience of the issue in popular culture, like, for example, assisted suicide. What is it that makes assisted suicide an important question? It's not a big part of the economy. It doesn't require billions of dollars of expenditures. What makes it an issue in popular culture is it's something where, as they said in the past cases, there's been earnest debate. It's a big moral question. People have introduced state level referenda about it, which succeeded in some cases and didn't succeed in others. And so you have to kind of come to a conclusion about how important something is in popular culture. And that's like turning judges into pundits. I don't like that. And, the same court and much the same majority took a very different view in the Dobbs case, where they just overruled Roe v. Wade and Casey. One of the reasons people said of why you shouldn't overrule Roe v. Wade and Casey is because you have to follow stare decisis, because otherwise the court is going to lose legitimacy. And the court said, we're not going to look at popular attitudes about the court. That's not something we're good at doing. We don't know how to do it. And even if we did know how to do it, we wouldn't be legitimate if we thought about it. We should just ignore what social movements there are, and we should just apply the law as we see it. And in fact, caring about the social movements that want us to go one way or another, that's what would make us illegitimate. Whatever you think about Dobbs, as the merits of that particular case, I think that specific attitude about social movements and popular attitudes, I think that is the right attitude for courts to take. And I do not think that courts should think about the gestalt of how important something is in the popular consciousness. And again, I don't think they're very good at doing that. There's another business here. What about focusing on Congress's consideration and rejection of bills? Now, that is generally disfavored. That's what we call negative legislative history. If you look at Congress, at the failure of a bill in Congress, it's not just legislative history of something enacted, it's the legislative history of something that was not enacted. And I can show you a ton of cases that say that is not a very reliable method, because there are a lot of reasons, a lot of random reasons why a bill could fail. And in fact, like, what if there was a bill that wanted to give the CDC the ability to impose an eviction moratorium? And what if that bill failed? It's possible that it failed because some members of Congress thought that it was a horrible idea and should never be done. And other members of Congress thought that the bill was unnecessary because CDC already had that power. So interpreting negative action by Congress is really perilous. And the Supreme Court has rightly argued against that many times. And moreover, that's even if you like legislative history. If you're a textualist, as of course many of the conservative majority are, then that's even worse. The dissent in West Virginia points this out, and Gorsuch says, well, it's not the same, because I don't want to use negative legislative history for actually interpreting the statute. I just want to use it at this threshold question of whether it's a major question. But to me, it seems equally problematic either way, because the reasons why negative legislative history is no good are good reasons, and it doesn't matter why you're using it. Now, the final thing I want to say about that is that the same thing I said for the benzene case. This clear statement rule does not match up very well with the non-delegation doctrine that supposedly enforces, because the non-delegation doctrine says you should have an intelligible principle. And that has nothing to do with whether the power is very broad or novel Oh, sorry, there was one other thing I wanted to put in there, but I forgot to put a bullet point about it. The idea that if it's a newly asserted power by the agency, like if the agency hasn't tried to use the power for the 40 years that we've had the statute, and now it's pulled out this new power. Well, I mean, maybe the EPA hasn't used that power because it hasn't thought it necessary. Maybe it always thought it had that power. And even if it didn't, maybe it was wrong back then. So I certainly don't want to encourage a situation where you encourage agencies to adopt maximalist views of their power from the very start, because now you're threatening them. If you don't adopt a maximalist view from the start, then 40 years later, you might be precluded from ever taking that view, even if it was correct from the start. And so I don't really want to be encouraging agencies to be maximalist, merely in order to preserve their future possibilities for regulation. Okay, and then my final point is the clear statement rule does not match up very well. That is, the non-delegation doctrine wants us to have intelligible principles, and intelligible principles are about how bounded the power is in terms of where does the power begin and end, right? It's not an arbitrary power, and that is different than whether the power is broad. That is, if Congress allowed an agency to regulate the whole economy, but it explained exactly how, then that would not violate the non-delegation doctrine. Breadth is not the problem. Unboundedness is the problem, or arbitrariness is the problem. So the clear statement rule does not match up very well with this non-delegation doctrine that supposedly enforces, so I don't think it really works as an avoidance canon. And then I'm going to finish with what I put in red as the last line. All of that, however, takes as given our current non-delegation doctrine. And one thing we know is that Justice Gorsuch is raring to revive the non-delegation doctrine and make it stricter. And he said so in a case just a couple years ago called US v. Gundy. And it looks like he probably has a majority for the general idea of reviving the non-delegation doctrine, but we don't know what it's going to look like. And so we've got these tantalizing hints, because he said what he said in Gundy, now he said what he said in West Virginia, and it could be that if we have a very different non-delegation doctrine a couple years from now, then maybe the major questions doctrine will play a different role. And maybe it will make more sense then as a kind of avoidance canon for that new and revived doctrine. But that's something that I do not know how to prognosticate on. And that's just something that we're going to have to look out for in the years to come. So that is all I have to say about that. And I'm glad to take questions.
Hey there, Professor. Can you hear me?
Yes.
Hey there. I'm Alan Lightcap. I actually had the other Professor Volokh at Emory back in 2012 for my seminar, and I had a seminar on Congress, and actually I thought that I would want to kind of ask you to react to where I think this might be going, where you have a very, very complex federal government that does so many different things. We have a reassertion of a previously basically dustbin of history doctrine of the non-delegation doctrine. And you have now perhaps a place where the court system is going to take back control from administrative agencies, the power to regulate complex issues in our economy. Congress might not take kindly to the pendulum swing that the courts are now taking away from their power to delegate. And I'm wondering if you think that one of the ways that Congress might try to reassert their authority to create administrative agencies with broad statutory or with broad power is to limit Article 3 courts under Sheldon and Sill, and Article 3 just basically do jurisdiction stripping of federal courts to even try to reassert this resurgent non-delegation doctrine. And I just wanted to know, knowing how, I guess, backwards and unfunctioning Congress is, I'm not sure if Congress is up to the challenge of having a intelligible principle. And that's my last, that's my joke, but anyway.
Yeah, so you know, I think that let's say, well, so for example, if suppose the Supreme Court took a very big step and overruled Chevron and said, you know, from now on, we are massively limiting the delegation that you've been doing all along to agencies. From now on, if you have a vague term, that's not a delegation of interpretive power to agencies. It's a delegation of interpretive power to courts. And we figure out what the ambiguous terms mean. Agencies can say what they say. We will respect their expertise to the extent they use their expertise. But if we're not convinced, we're going to decide the meaning of a statute. And what if Congress doesn't like this? Now, it's not obvious that Congress wouldn't like it because in this very polarized world, you know, there's always one party that likes it, one party that doesn't like it. And I mean, unless we have one party controlling the presidency in both houses of Congress, it's of course difficult to overrule what the Supreme Court does. But let's suppose Congress was unanimous that we didn't like that. What could they do? And there's a couple things they could do. And one thing they could do is very simple. They could adopt Chevron by statute. Because I don't believe that Chevron is unconstitutional. I also don't think Chevron is constitutionally mandated. Chevron is just a matter of federal administrative common law, and it's just a rule of interpretation that that the federal courts have adopted. It's a presumption about delegation of interpretive power. You know, presumption of what would Congress have wanted to do? Well, it's easy. Congress can just say what it wants to do. So one way that it could do is it can adopt a Chevron Reestablishment Act. And it says that whenever there is an unclear term, then courts ought to defer to reasonable agency interpretations. And they can even overrule Meade if they want. They can make it broader and make it extend toward interpretive memos, or they can make it narrower. So they can do a wholesale Chevron Reestablishment Act. And another thing they can do is they could put it statute by statute. In fact, Congress did that in Dodd-Frank. In Dodd-Frank, there are some sections that say these kinds of determinations by agencies get Chevron deference, and those kinds of determinations get Skidmore deference. So it wouldn't require any very radical change. If the Supreme Court does it and Congress doesn't like it, Congress can just reestablish what there was before. Now, if the Supreme Court makes a constitutional ruling, like now lots of things Congress did are unconstitutional because they don't have an intelligible principle, I don't think it would be very difficult for Congress to go back and amend a bunch of statutes to supply intelligible principles. I mean, of course, I don't know what that doctrine will look like. So it's possible, you know, Justice Thomas has a very extremist view of what the non-delegation doctrine should look like. He doesn't think there should be any discretionary power at all. But I don't think anyone else takes that view. So I think quite plausibly, Congress will be able to, going forward, just be more careful about its delegations, and also, as to the past statutes, can supply intelligible principles. As to jurisdiction stripping, yes, I mean, if Congress doesn't like what the court is doing, it can strip the courts of jurisdiction. That's probably allowed under the Constitution, though it hasn't really been tested in these very ideological cases. But here's the thing. Congress has always been threatening that. They've threatened to do it about school prayer. They've threatened to do it about flag burning. They've threatened to do it about busing, and it hasn't happened. And partly, I think it'd be contrary to norms, and partly it would require an extreme amount of anger at the court, and it would require also a lot of bipartisanship about the solution. So I'm not terribly concerned. I'm not terribly concerned about that happening.
Well, thank you.
I think I have a question. Has major questions, has it ever come up in state courts or at the state level?
Oh, that's a fascinating question. And I have a very quick and correct answer to it, which is I have no idea.
Any more questions? I did this might be kind of a dumb question. Could the non-delegation doctrine, could that have come up more forcefully in West Virginia? I'm sorry, yeah, West Virginia versus EPA is like even as just an avoidance canon type thing, or is it? Because I do remember non-delegation coming up in a Georgia case, and the name, I think it was UHS of Anchor, and it was essentially, if this provision does mean this, then it would violate the non-delegation doctrine. So
I remember that case. There definitely it was non-delegation that came in as an avoidance doctrine. Yes, but I mean, I think that it's kind of implicit in what the majority is saying, and explicit in Gorsuch's concurrence is we use this as an avoidance doctrine. That is what the court said in all those cases, Brown and Williamson and Gonzalez v. Oregon about the suicide, and all those cases, what the agency was asserting was not crazy. It had a textual basis in the statute. And so if you were blind to whether this was a major question, you might have ruled in favor of the agency. But once you consider major questions, then it's then you realize that actually it's implausible and so on. And as Gorsuch says, we justify this as a canon to enforce the non-delegation doctrine. So yeah, this is something that Georgia courts have been doing, and it's something that now it looks like the US Supreme Court is getting back into the business of. Now, I gotta say, Brown and Williamson, I like the result, but I really hate the reasoning. And if I had been there, I probably would have concurred in the judgment on a totally different ground, which is that you just shouldn't consider cigarettes and nicotine to be drugs and devices because they're not about curing disease. But like this whole idea that you look at the gestalt of the statute in light of all these statutes that have been passed since, and then it turns out that it's a bad fit for the FDA, in light of the very broad definition of drug and device in the Food, Drug, and Cosmetic Act, that makes me very uncomfortable.
Thank you. Any other questions?
I have another one. What administrative agency do you think has the most exposure in knowing where the law is going, in kind of seeing what the next case that we're going to be talking about in 2 years is going to be? Like, where do you think this is going?
Interesting. Well, that's a very difficult question, because we have these very big and controversial cases coming up in so many different areas. So like one big area that these things have come up is immigration. You had Obama with DACA and DAPA, then Trump repealing those, and so on. So I think that immigration is a very big area where these admin questions come up. Now, that's probably not the best area to talk about non-delegation doctrine, just because the federal courts have usually said, well, the executive branch has more leeway when it comes to foreign affairs and international relations and things like that. And that probably, in light of immigration cases like the Arizona case, probably your non-delegation challenges will have less purchase there. So clearly there have been a lot of environmental challenges. So I wouldn't be surprised if environment is one of those places where it happens. Now, I mean, recently we've also had a bunch of these CDC challenges, but it's possible that those are very tied to the COVID context. And as COVID recedes, then we'll have fewer cases like that. On the other hand, even if COVID recedes, public health emergencies might not recede. So that might be a continuing thing. So, I wouldn't be surprised if the next case actually does involve, in fact, does involve environmental issues.
Well, I definitely think COVID created an exigency for agencies to try to, regulate. And then once you try to occupy into a new space, then that will breed litigation, which is where these court challenges come up. So,
Right.
Interesting.
Oops. So one thing that I have done, by the way, is I have just posted 2 YouTube links in the chat, and at your leisure, you can copy those for yourselves, and at your leisure, you can watch them. But there are 2 songs that I recorded, and one of them is about interpretive canons, and it's called "You Don't Need a Canon to Interpret My Heart." And the second one is the Ballad of FDA v. Brown and Williamson.
Hilarious.
Yeah, I love it. Anyone else? Okay, well, I think we're about at time. So, yeah, if there's no further questions, then I think that'll do it, and we can call this presentation. Thanks so much, Professor Volokh, and I know everybody here would join me in thanking you. It was fantastic. Learned a lot. It's a pleasure as always.
Thanks very much. It's my pleasure.
Yeah, thank you.
Ladies and
Thank
gentlemen,
you.
this does conclude today's presentation. Thank you for joining and have a great afternoon.